this is part 10. As far as part 9 is concerned, I had just introduced to you section 14, which defines negotiation, and then section 15, which deals with endorsement. But then, before we start with the provisions as far as negotiation and endorsement is concerned, let me start discussing chapter 3. And it's not that we are going to take into consideration chapter 3 right from section 26 up to section 45A of the Negotiable Instrument Act. Certainly not. But today, right in the beginning, let us try to understand as to who can be a party to a promissory note, bill of exchange and check. In other words, parties to notes, bills and checks is the heading of the chapter. And then to know this, as you start discussing right from section 26 and come up to section 29, that serves the purpose from the point of view of knowing as to who can be a party to a negotiable instrument. Now, before we start with that, then it goes without saying that whether it is a promissory note, whether it is a bill of exchange or whether it is a check, these are all the contracts, and hence who can be a party to it? One who is competent to contract. So who is competent to contract? For that, this is a time for me to draw your attention to section 11 of the Indian Contract Act. So the party who is competent to contract as per section 11 of the Indian Contract Act can be a party to a promissory note. Namely, he can be, we start reading section 26 says, every person, section 20, heading of sections 26 says, capacity to make etc. promissory note etc. And what it says? It says, every person capable of contracting according to the law to which he is subject may bind himself and be bound by the making, drawing, acceptance, endorsement, delivery and negotiation of a promissory note, bill of exchange or check. So one, the person who is capable of contracting, and nowhere in the Negotiable Instrument Act it has been mentioned as who is competent to contract, for which there you should have reference to section 11 of the Indian Contract Act. One who is competent to contract. And for what? Now, he is according to the law to which he is subject, and what he can do? May bind himself. So what he can do, if he is competent to contract, he may bind himself and be bound by. So he is he can sue or you can proceed against him in a court of law because in that case he is competent to contract. So it says may bind himself. So there will start his liability and be bound by the making, drawing and acceptance. So these are the parties who can make a negotiable instrument, draw a negotiable instrument, and there can be acceptance of a negotiable instrument, there can be endorsement, there can be delivery and negotiation of what? Of a promissory note, bill of exchange or check. And now, as compared to the Indian Contract Act, if you come to section 26, it speaks about this is a special enactment and has made a provision for minor. And what it says? A minor may draw. So minor is not competent to contract as far as section 11 is concerned. But section 26 says a minor may draw, minor may endorse, he may deliver and negotiate such instrument so as to bind all parties except himself. So when the minor can be a party to a negotiable instrument, but minor, what he can do? He can be a party to a negotiable instrument so as to bind all parties except himself. So minor is never liable. No, all other parties are liable, no doubt about it, but except himself. And the further part of section 26 says, nothing herein contained shall be deemed to empower now further part. So this is with respect to what? Can a minor be a party to a negotiable instrument? Yes, minor can be a party to a negotiable instrument. So what minor can do? Minor may draw, minor may endorse, minor may deliver, minor may negotiate such instrument so as to bind all parties except himself. So minor is not at all liable, but other parties are liable as far as such a negotiable instrument is concerned. Now with this, now the next part of the section deals with what is, can a corporation be a party to a negotiable instrument? And it says, nothing herein contained shall be deemed to empower a corporation to make, endorse or accept such instrument, except in cases in which under the law for the time being in force they are so empowered. So whether company or corporation can be a party to a negotiable instrument, and the answer is it's not. It's not as per the Negotiable Instrument Act, because it says nothing herein contained shall be deemed to empower. So Negotiable Instrument Act doesn't empower a corporation to make, endorse or accept such instrument, but it says except in cases in which under the law for the time being in force they are so empowered. So if the company is there is a provision as far as company is concerned in memorandum of association that yes, the power, if the company is empowered, yes, then company can be a party to a negotiable instrument. As far as corporation is concerned, when you deal with charter of incorporation, as far as corporation is concerned, and if that is empowered, if there is a provision that that this can be, the company or the corporation has got power to make, endorse or accept, then by all means corporation can be a party as far as negotiable instrument is concerned. With this section 27, and what is section 27? It says every person capable of binding himself or of being bound as mentioned in section 26 may so bind himself or be bound by a duly authorized agent acting in his name. So one who is competent to contract can be a principal, and then if the act is done by the agent, so what do I mean? Every person capable of binding himself, what he can do, or being bound as mentioned in section 26 may so bind himself or be bound by a duly authorized agent. So in that case, if the act is done by the agent, that will be binding on the principal as far as the say relation between principal and agent, which is dealt as far as agency is concerned, with which when you deal with the provisions of the Indian Contract Act. And what the further part of the section says, a general authority to transact business and to receive and discharge debts. So when the principal has given agent general authority to transact business and receive and discharge debts, does not confer upon an agent. So that does not confer upon an agent the power of accepting or endorsing bills of exchange so as to bind his principal. So there can be general authority to transact business and to receive and discharge debt, but that does not confer upon an agent the power. So this cannot be done by the, if this is done by the agent, that will not be binding on the principal, does not confer upon an agent the power of accepting. No, there cannot be acceptance or endorsing bills of exchange so as to bind his principal. And last part, an authority to draw a bill of exchange does not of itself import an authority to endorse. So there can be an authority, to whom authority given to an agent, and what agent can do? he can have an authority to draw a bill of exchange, does not, but that does not of itself import an authority to endorse a bill of exchange accordingly. With this now, what is the liability of agent when he signs is the next question, which is dealt by section 28, and it says an agent who signs his name. So what agent has done? An agent who signs his name to a promissory note, bill of exchange or check. He has signed his name to a promissory note, bill of exchange or check without indicating thereon. He doesn't make mention on the negotiable instrument without indicating thereon that he signs as agent. So he has signed, but he has not indicated that he has signed as agent, or that he does not intend thereby to incur personal responsibility. So if he doesn't make mention that he does not intend thereby to incur personal responsibility, in that case he is liable. Such a person is liable on the instrument. Such a person is liable, such agent is liable on the instrument, except to those who induced him. So he is liable to all except whom? Except to those who induce him to sign upon the belief that the principal only would be held liable. So if those who have induced him to sign upon the belief that the principal only would be liable. So when the agent is liable, when he signs, is made very clear as far as section 28 is concerned. With this now, section 29 deals with liability of legal representative. A legal representative of a deceased person who signs his name to a promissory note, bill of exchange or check is liable personally thereon unless, so when legal representative signs, he becomes personally liable thereon unless he expressly limits his liability to the extent of the assets received by him as such. If it is made very clear after the death of any one of the parties to a negotiable instrument, his legal heir will step into his shoes. That is the practice when you will deal with the provisions of the Civil Procedure Code, maybe after death of the plaintiff or maybe after the death of the defendant. His legal heirs will step into his shoes. And then what is liability of legal representative? And here it says a legal representative of a deceased person who signs his name to a promissory note, bill of exchange or check is liable personally thereon. He is liable, he becomes personally liable unless, but if he has expressly limited his liability to the extent of the assets received by him as such. So in that case, for example, he is not at all personally liable, he is liable only to the extent of the assets received by him as such, otherwise he becomes liable. Similarly, this is one part, but for example, what is the liability of the Karta of joint Hindu family property? If he signs in that capacity, for that as there is no provision which is made as far as the Negotiable Instrument Act is concerned, but in that case you have to refer to the personal law, namely the Hindu law, and try to find out. So there, during course of time, there can be addition to this list, namely parties and what is their liability to certain extent. But now we shall be confining our discussion to this as far as right from section 26 up to section 29, and then the further part right from section 30 deals with liability. What is the liability of the drawer? 31 deals with liability of drawee of a check. 32 deals liability of maker of note and acceptor of bill. And then further part with which we shall have a passing reference during the course of time as we shall be dealing with the provisions of the Negotiable Instrument Act. With this now, the time for me to draw your attention that we were discussing section 14 of the Negotiable Instrument Act. And at the time of discussing section 14 of the Negotiable Instrument Act, we did learn section 14 defines negotiation, and it says when a promissory note, bill of exchange or check is transferred to any person so as to constitute the person the holder thereof, the instrument is said to be negotiated. So what do you mean by when it can be said that the instrument is negotiated? It says when a promissory note, bill of exchange or check is transferred, so it passes from one hand to another hand to any person so as to constitute. But how? So that I mean the transfer is so as to constitute the person the holder thereof. So it is transferred from one person to another person, but then in that case the person to whom it is transferred, namely it constitutes transferee holder thereof. Then we say this is what is known, the instrument is said to be negotiated as far as section 14 is concerned. But then, as I had told you yesterday, if you remember, when during part number 9, that this section is required to be correlated with the chapter 4 of the Negotiable Instrument Act, and the heading of the chapter is of negotiation. And out of this now, if you start reading section 46, it says the making, acceptance or endorsement of a promissory note, bill of exchange or check is completed by delivery, actual or constructive. So this is, I mean, there must be a delivery. Unless there is a delivery, then the making, acceptance or endorsement of a promissory note, no, it's not at all complete. When it will be complete, delivery is complete. I mean, delivery may be actual, you physically hand over a negotiable instrument to him, or he gets an authority because it is handed over to somebody who has got an authority. That is what is known actual or constructive delivery. So there, it's not necessary that there should be actual delivery, there can be constructive delivery also, but delivery is a must. And what the section starts with the wording, the making, acceptance or endorsement of a promissory note, bill of exchange or check is completed by delivery, which may be actual or constructive. Now further part says, as between parties standing in immediate relation, delivery to be effectual must be made by a party making, accepting or endorsing the instrument, or by a person authorized by him in that behalf. So who can make a delivery? A delivery as between parties standing in immediate relation. Delivery, so it can be from maker to the payee. It can be payee who puts it into circulation, namely endorser to the endorsee accordingly. So it says delivery to be effectual must be made by a party making, accepting or endorsing the instrument, or by a person. So it can be by the person who is making the same, accepting the same or endorsing the instrument, or by a person authorized by him in that behalf. Next part of the section says, as between such parties and any holder of the instrument other than a holder in due course, it may be shown that the instrument was delivered conditionally or for a special purpose only, and not for the purpose of transferring absolutely the property therein. So this can be only between the parties, and this we will discuss at the time when we try to understand the right of the party who has got right to recover amount from all, namely the right of the holder, during course of time as we start with the procedure. But the further part of the section says, a promissory note, bill of exchange or check payable to bearer is negotiable by delivery thereof. So if it is a promissory note, bill of exchange or check is payable to bearer, it is negotiable by delivery thereof. If a promissory note, bill of exchange or check is payable to order, is negotiable by holder by endorsement and delivery thereof. Now, as we proceed further. So, depending upon the nature of the instrument, whether it is a bearer instrument or whether it is an order instrument, and then as we start, section 47 makes mention of what negotiation by delivery, and it says, subject to the provisions of section 58, with which we shall be dealing, a promissory note, bill of exchange, or check payable to bearer is negotiable by delivery thereof. So when a negotiable instrument is payable to bearer, it can be negotiated by delivery only. And then delivery is a must, because that we have dealt as far as section 46 is concerned. To which now the exception to section 47 says, a promissory note, bill of exchange, or check delivered on a condition that it is not to take effect except in a certain event is not negotiable except in the hands of a holder for value without notice of the condition unless such event happens. So this is the part with which we shall be dealing in detail, but for the timing you can read the illustrations which are given as far as section 47 is concerned, but we will try to understand this as far as during course of our lectures is concerned. With this now, the there can be negotiation by endorsement, and it says, section 48 says, subject to the provision of section 58, a promissory note, bill of exchange, or check payable to order is negotiable by the holder by endorsement and delivery thereof. Now this has got reference to section 15 as far as the endorsement is concerned, and this is a time as we start learning this process. We will come to know that this is there must be an endorsement. So what do you mean by endorsement? It says, when the maker or holder of a negotiable instrument signs the same otherwise than as such maker for the purpose of negotiation on the back or face thereof, or on a slip of paper annexed thereto, or so signs for the same purpose a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called the endorser. Now, he is such a person is what is known as an, so if it is an order instrument, there must be an endorsement, and what he will do, this is how many endorsements can be there, where the endorsement is to be made. I made mention of it to certain extent, but we shall be dealing with this in detail during course of our lecture. But then now, this is a time for me to draw your attention to that in case when there is an endorsement. Now, for the purpose of understanding endorsement, so now the time for us to understand endorsement, and what we are supposed to do, we are first of all, this is the time first of all, there can be n number of endorsements. So in order to, first of all, we will deal with section 15, no doubt about it. But then along with section 15, there are many more sections that we will have to refer, so that it becomes possible for us to understand provision as far as the endorsement is concerned. Now what is endorsement? The person signs on the back of the negotiable instrument. And why he signs on the back of the negotiable instrument? Because he wants to put that negotiable instrument into circulation. What is the nature of the instrument? It is order instrument. And in case of order instrument, what is required? Order instrument can be negotiated provided there is an endorsement, that is one aspect, and delivery endorsement, and second is the delivery of such an negotiable instrument. Yes. But then If there can be, as I told you, there is no restriction, there is no restriction. Depending upon the nature of the instrument, it can be negotiated by order instrument, it can be negotiated by endorsement and delivery. It is on the back of it, it is on the back of the negotiable instrument. So back of the negotiable instrument for all practical purposes is treated as a negotiable instrument itself. And hence, now this is the time for me to right in the beginning draw your attention to spatial rules of evidence with which you are dealt to a certain extent as far as chapter 13 of the Negotiable Instrument Act is concerned. And when you start reading section 118 and come to small e, what is a presumption? And it says, as to order of endorsement, that the endorsement appearing upon a negotiable instrument were made in the order in which they appear thereon. This is the presumption. Now, why it is necessary for you to know the order of endorsement? Namely, if it is a negotiable instrument drawn in favor of B, B is the first person who shall, namely the payee, who will put it into circulation. B to Mr. D, D to Mr. E, E to Mr. F, F to Mr. G. And then G has got, if it is not honored, G has got right to recover amount from prior party. But in order to know prior party, it is necessary for you to know the order of endorsement. And this will help clause a small e, as far as section 118 is concerned, will make everything, simplify everything, make it very clear. That is, that the endorsement appearing upon a negotiable instrument were made in the order to which they appear thereon. So if it is first, his signature is by B, then signature is by D, then by E, then by F, then by G accordingly, then it is possible for you to know as to the negotiable instrument is transferred from which person to which person can be made out very easily when you just refer to the order of endorsement which appears on the negotiable instrument. With this now, at the time of discussing details as far as endorsement is concerned, if B may merely put his signature, yes, he can put his signature, but B can write above the signature, please pay to D, and he can put his signature. Or it's not only he will always write please pay to D, sometimes he may write something other than that. And hence now, this is the time for us to understand as to various kinds of endorsement. For the purpose of knowing various kinds of endorsement, there can be what is known as endorsement in full, there can be what is known as endorsement in blank, there can be what is known as conditional endorsement, there can be what is known as restrictive endorsement, there can be what is known as partial endorsement, or there can be what is known as sans recourse endorsement, where the person makes it very clear that I put it into circulation, but there is no recourse to me. That is also the provision with which we shall be dealing. So now, as far as the next lecture is concerned, we shall be trying to club the sections together. So 15, yes, but along with 15 we shall be dealing with section 16. We shall be dealing with section 54. We shall be dealing with section 55. And then as we proceed further, we will deal with section 48, section 49, section 50 and section 52 to be read with section 56. So we will try to understand different kinds of endorsement. And as far as the liability of the endorser is concerned, we shall be dealing with section 35, section 38, section 40 and section 41. These are the sections with which we shall be dealing, so that we can have general understanding as far as the endorsement is concerned, with which we will continue our discussion as far as next part of our lecture is concerned.